So to start with, the decision is a decision of the High Court of Justice in the UK. And here the case was between Tesla on the claimant side, and on the defendant side, we had two companies. We had, on the one hand, InterDigital, an SEP owner, and also a licensor of its own portfolio, but also a licensor that has joined Avanci, which was the second defendant in these proceedings here. Avanci is a licensing platform which offers licenses to, among others, wireless SEPs, referring to 4G and 5G, tailored to the automotive sector. So this was the setting here. We had Tesla basically suing InterDigital and Avanci in the UK, and we're going to see in a moment what were the actual claims that Tesla raised in these proceedings. Just some basic facts on the story behind the case. Tesla, of course, is known as an electric vehicle manufacturer. The cars that Tesla has been producing so far have all 4G capabilities. This means that Tesla needed to license this technology. And what Tesla did was to take a license from Avanci regarding 4G. This was done, so 4G was covered in a sense. But now Tesla would also start introducing 5G capabilities in their vehicles, and the question of licensing arose again. Now, what Tesla did here was apparently to sign a license, a bilateral license, with one of the patent owners and licensors that are part of the Avanci pool, but at the end of the day did not seem to want to sign other bilateral agreements with other licensors, but seeks to have a license, a 5G license from Avanci, from the platform, from the pool. This was the main ask of Tesla. Where comes InterDigital in this context? Apart from being member of the Avanci pool, InterDigital did not have rather a specific involvement with Tesla on a bilateral level. So it did not threaten infringement proceedings against Tesla. It did also not have any bilateral agreement signed with Tesla. But nevertheless, when Tesla raised this suit filed this suit in the UK, it raised the claims against both InterDigital and Avanci. So here, maybe just to give a first impression of what this case was about, mainly the ask that Tesla had for the UK court was to determine, on the one hand, that the terms of the Avanci portfolio license, and here again, not the terms that InterDigital might offer for its own portfolio, the focus was placed on the Avanci pool license. So the one ask was that to determine that these terms for the 5G Avanci license are not FRAND. And of course, if you would succeed with that, Tesla would like the court in the UK to also determine the right FRAND terms for a license to Avanci, to the Avanci 5G portfolio, against for a global license in particular. So this was the main subject matter of these proceedings, what was in the focus of the court. And before the court went into actually examining these claims in detail, it had to discuss the jurisdictional question before, basically because here the defendants, both defendants, InterDigital and Avanci, were not UK based. So the question was here, should the court at all start dealing with this decision, with this dispute? Does the court have jurisdiction to deliver a decision on the claims that Tesla has raised here? And with this judgment here, the court actually declined jurisdiction for the claims that Tesla has advanced. It declined, meaning jurisdiction for determining also what was one of the claims that have been raised. It declined jurisdiction to determine the terms for an Avanci 5G license. We have not seen any development beyond that in this dispute, so it's not clear, at least from public available sources, whether this has been appealed or not. But of course, we will be looking out to see if this case moves on, and we will report respectively in our webinars here. So when we look now at the legal analysis of the court, the first thing that we should look at is the actual claims that Tesla has raised here. So there were, let's say, two different categories of claims that Tesla raised. One of them was the first category were what the court described as patent claims. These were, let's say, very ordinary claims that referred to UK patents held by InterDigital. And here again, the remark that Avanci itself does not hold any patents. It's the individual licensors that have joined Avanci that hold patents. So these patent claims, which basically asked for a declaration of invalidity, non-essentiality, or revocation of 3 UK patents, were directed against patents that InterDigital holds. The other part of the claims of Tesla were the so-called licensing claims. And these were also the claims on which the court focused here, not least because Tesla asked the court to prioritize these claims over the patent claims in these proceedings, meaning to start with the licensing claims and then eventually go to the patent claims. These licensing claims had, we're going to see in a moment in more detail what exactly was asked by Tesla. But in principle, these were two elements. One, a declaration about the availability and the terms of a 5G SCP license of the Avanci pool. And the second one, of course, what we have mentioned already, the determination of front terms for a 5G SCP license by the pool. So these are the claims on which the court focused, and this decision actually focused here. Now, what was this exactly what Tesla's licensing claims included? First, Tesla sought a declaration that the terms of the Avanci license are not FRAND insofar as they relate to UK patents in the Avanci 5G pool. Alternatively, a declaration as to which terms are FRAND for UK patents, and again, further alternatively, only for UK patents owned by InterDigital. So the first declaration was regarding basically the actual terms of the Avanci license. So what Avanci offers in the market for 5G, Tesla wanted a declaration by the court that these terms are not FRAND. Then Tesla sought also a declaration that a FRAND license, which would cover the patents in suit here, again, these are InterDigital patents, 3 UK InterDigital patents, or all InterDigital patents in the UK, or all InterDigital patents globally, would be a global license, and that license would be an Avanci license signed between Tesla and Avanci, which would cover the entirety of the Avanci 5G pool. So here, basically, the argument which was underlying this request was to say that for the patents that have been attacked here with the patents claims, and for any patent that is relevant that UK InterDigital holds, either whether it's a UK patent or a global patent, the only FRAND license would be a pool license by Avanci, which would cover everyone that is a licensor in Avanci. That was the second declaration that Tesla sought in these proceedings. Furthermore, then Tesla sought also declaration that Avanci is required to enter into a 5G platform license with Tesla on FRAND terms. And of course, subsequently, also a determination of the terms of a FRAND 5G license, especially if the court would find that the existing terms that Avanci offers in the market were not FRAND. So these are the claims, the most important, let's say, claims which Tesla raised in these proceedings. Now, the court had to decide whether it has jurisdiction on these claims or not. The applicable standard here is the one mentioned in the slide. We have basically 4 different conditions that need to be made under UK law. We have the first condition that you have to have a serious issue to be tried on the merits. In other words, this means that the proceedings should deal with an issue that needs a court decision to be resolved, as something that is definitely or truly in dispute between the parties, where the court should intervene and provide a solution. And this is the first condition, which was also the most prominent one in these proceedings, on which the court primarily focused in its analysis. There are other conditions as well. For example, the second condition, that you have a good arguable case, that one of the gateways for service out applies. This is a more, let's say, technical procedural issue. There are certain cases where the courts are allowed to grab jurisdiction even if the parties are not based in the UK. This requirement should be met. So one of these gateways, these are called gateways, should be met. And then there are another 2 conditions which focus a lot on the idea or on the concept of appropriateness. So here the court needs to examine, for example, whether the England and Wales is clearly and distinctly the appropriate form for the trial, and also to examine whether it's appropriate to permit service out of the jurisdiction. The court focused, as I said already, on the first condition, which was the question whether there is a serious issue to be tried on the merits. Provided, however, also some insights on the question on the third condition, whether the UK would be the appropriate forum for the trial, respectively, which would be the appropriate forum for the trial. We're going to take a look at that at the end of the presentation. What were the thoughts of the court regarding this specific point here? Now, when we look at this first condition, what is interesting here to note is that the court split its analysis between the case that has been advanced against Avanci on the one hand, and the case that has been advanced against InterDigital on the other hand. So, to put it in other words, it basically tried, at least in this analysis, to look at the parties individually and see if there is an issue, a serious issue to be tried against Avanci, and if there is a serious issue to be tried against InterDigital. It started its analysis with Avanci first. And here, what was also interesting is that the court basically examined 2 different scenarios. It looked at whether there is an issue to be tried against Avanci if you would look at the case independently from the case that has been filed against InterDigital. And the second option here, or the second scenario, was if the case against InterDigital would proceed. So would the assessment change, basically, or not? And regarding the first aspect here, if you look at the Avanci case brought by Tesla independently from the case against InterDigital, the court said that there is no serious issue to be tried against Avanci. So in this isolated perspective, the court found that there is no reason to start proceedings. There is no real case against Avanci if you look at it individually, independently from the case against InterDigital. The court then said if you would, however, look at the case of InterDigital in connection to the Avanci case, and would assume that the case against InterDigital would proceed in the UK, then likely you would have a serious issue to be tried against Avanci, which would, of course, open up the jurisdiction of the court to hear the case. The court said here, in this case, if we would allow the case against InterDigital to proceed in the UK, Avanci would likely be a necessary or proper party to these proceedings, which, to put it in other words, means basically that it would have made sense for Avanci to join these proceedings if the case against InterDigital would move on. This was, however, not a very important or a very great discussion at the end of the day in these proceedings here, for two reasons. One, the most important one, was that that Avanci had already signalized that if the proceedings against InterDigital would proceed, it would join the trial. So it had an interest in doing that. So it would not contest the jurisdiction of the court in this case, but would join the proceedings and participate in the trial. And the second reason why this was not a big part of the discussion here was that, as we're going to see in a moment, the court found that the case against InterDigital should not proceed in the present proceedings. So the focus again was placed on the first angle, whether there is a serious case to be tried against Avanci alone, independently. And here the court said, as we said, no. And the reason for that was that the court did not see a real and present dispute between Tesla and Avanci about the legal right. So it heard the arguments of the parties here, especially the arguments on Tesla's side, but was not convinced that there is a real dispute about a legal right that exists here between Avanci and Tesla. And in other words, the court did not see that there is a relationship between Tesla and Avanci from a legal perspective that could basically create a dispute that would be worth for the court to decide here, or that could give claims to Tesla against Avanci. Here, there were two different aspects that were argued concerning a potential legal relation between Avanci and Tesla. And the first one was also formulated as a request. So whether Avanci would be required to conclude a license with Tesla. Of course, if you would have agreed that there is some legal basis that such an obligation exists, this would mean that there would be a dispute here that should be treated by the court, and you would have eventually the jurisdiction open. But the court, at the end of the day, did not see any independent basis on which Avanci is required to conclude a 5G platform license with Tesla. There was some discussion here about the extent of the front undertakings of the licensors that have joined Tesla, or whether Avanci itself has a front obligation, etc. But the court, at the end of the day, was not convinced that there is a claim on the side of Tesla which would require Avanci to conclude a 5G platform license with Tesla. So this was the more obvious obvious part of the discussion. There was a second argument as well concerning a potential legal relationship between Tesla and Avanci. That was an argument that if the licensors that have joined Avanci would fail to grant a front license to Tesla, this could possibly create a claim of Tesla against Avanci, exactly due to this failure of the Avanci members, Avanci licensors, to offer a front license to Tesla. So the court heard arguments about that as well, but at the end of the day, again, it found that the possibility that Tesla would have a claim against Avanci because the licensors that are part of Avanci have failed to meet their front obligation and to grant a license on front terms to Tesla was too remote at the end. So it was not stable enough, not founded enough in order to start the proceedings based on this argument. And maybe here just a small footnote. When we are looking at this decision here, we need to keep in mind that we are at a, let's say, preliminary stage of the analysis of the court. The court did not really examine these claims at the merits. We are at a stage already before that, where the court just thinks whether in principle these claims can make sense and can have a legal foundation. And this is what the court denied here, especially when it comes to a case or claims or legal rights that Tesla could advance against Avanci individually. So we've seen now how the court treated the licensing claims from the perspective of the proceedings filed against Avanci. And now the court did the same with regard to InterDigital. Here the court again raised this question whether there is a serious issue to be tried against InterDigital in these proceedings. Again, focusing on the licensing claims, because on the, let's say, patent claims, especially when it comes to InterDigital, the jurisdictional issue was not a very big topic. It was clear here we have UK patents that are subject matter of the proceedings, so the court would most likely be competent to decide the case. But when it comes to the licensing claims against InterDigital, the same question was posed. Is there a serious issue to be tried? And the court made here again a distinction between two different scenarios. Again, the first scenario was whether you would consider the trial against InterDigital individually. So if there is a case to be tried against InterDigital alone, this was one aspect, and the court said no, there is no such case, serious issue to be tried against InterDigital. And the second aspect was a bit different. Here the court, and this was based on arguments also raised by the parties in the proceedings, especially by Tesla, whether you could basically have the trial proceeding on the assumption that InterDigital is not only leading the trial on its own behalf, in its own capacity, but also as a representative of all the other Avanci licensors. So this is something which has its roots in the procedural rules in the UK. We're going to see more in detail in a moment. But maybe already here, the answer also in this regard was no. So there also, if you would consider that InterDigital could act as a representative of the other Avanci licensors, you would not have a serious issue to be tried against InterDigital in these proceedings. Now let's take a look at the first part, and here the question is there a serious issue to be tried against InterDigital alone? No. The court said no. A little bit different the reasoning compared to Avanci, however. So regarding this question of whether there is a legal right, which we saw that in the Avanci context was not the case, the court said you could well argue that there is a legal right at issue if you look at Tesla and InterDigital, because Tesla could argue that it is beneficiary of InterDigital's ETSI front undertaking. Again, here, the court did not decide whether Tesla is actually a beneficiary of InterDigital's front undertaking. It said only that there is basically a legal relation that could be established between Tesla and InterDigital, and this the source could be the ETSI front undertaking. So it would make sense. You could argue that. There was then some discussion of, especially on InterDigital side, saying that, well, even if you say that there is a serious issue to be tried and there is a legal right at issue here, it wouldn't make sense to move on with the proceedings anyway, because as you said already, there is no obligation of Avanci to grant a license to Tesla, and this is the only thing that Tesla actually wants. So even if you would move on with a trial against InterDigital, the declarations that you would make would not make any sense in practice, would have no effect, because at the end of the day, since only the Avanci license is what Tesla wants, it is clear that Avanci is not obliged to grant this license. So the court said here, it is not pointless to make these declarations, even if you would assume that Avanci would not be obliged to offer a platform license to Tesla. From, let's say, a more factual background, by saying that if the court makes a determination and says that first makes a declaration that the actual Avanci terms at the moment are not front, and then moves a step further and also determines which terms are front for an Avanci 5G license, this would likely make the other licensors agree to offer these terms that the court would set then. So a practical impact or a practical effect could emerge even in this scenario. However, the court said that what you need to consider here, and this was the main concern of the court in this regard, was that going on with the proceedings only against InterDigital in the absence of Avanci or the Avanci licensors would not be fair and just. Especially, it would not be fair and just to grant declarations which Tesla sought in these proceedings, if both Avanci and the Avanci licensors were not part of the proceedings. There was, of course, one practical reason that InterDigital would not be in a position to properly advance those cases, because one element here was that it might most likely not have the relevant information that it needs in order to plead and advance those cases. And on the other hand, of course, the great problem was that you would have the licensors, the other licensors of Avanci, and we are talking about 65 plus other patent owners, not being able to put their cases before the court on what is actually a front license or what rate would be front for a license, either an individual license or particularly here the Avanci license. And considering that, the court said that it was very unlikely that the court would make declarations regarding rights which are capable of affecting adversely a number of parties who are not before the court. So here the main concern was basically that if you would agree that there is a serious issue to be tried against InterDigital and you would move on with these proceedings, you have a risk that you would make declarations at the end of the day which would have an impact far beyond InterDigital only, and cover also the rights or affect the rights or the position of the other Avanci licensors, which, however, would not be participating in the trial and pleading their cases before the court. So this was a major concern of the court here. And apart from that, apart from the fact that it would be problematic from the impact point of view, the court said that it would be also very difficult to make any of these declarations factually, because you would be most likely missing very relevant data and information. So the court mentioned here that it would not be realistically able to basically say and assess whether the Avanci rate of $32 for 5G is front, or what rate would be front instead. If there was no access to data, for example, the license agreements of the Avanci licensors, or information of the Avanci licensors about the value of their portfolios or the revenue streams, for example. All of these are relevant issues and relevant information, relevant data, which is available only to Avanci licensors or Avanci. So if you would move on with the proceedings alone against InterDigital, you would not be able to make these assessments, because you would just not be having access to the information you need, for example, regarding the rates. And not only that, you would also not have access or evidence, access to evidence that is needed in order also to determine the proper extent of a front license. Here, this is more about the scope of the license. For that, you would need, for example, evidence relating to the market practice. So what parties actually do in the market. And this, again, is information that InterDigital itself could not provide. This is information that the Avanci licensors and potentially Avanci itself would be able to provide, which would not happen, however, if they would not be involved in the proceedings. And the proceedings would be going only against InterDigital. So this was the first element. Then the court turned to discuss whether things might be different if you would assume that InterDigital did not act only on its own behalf in these proceedings, but if you would assume that it was acting also as a representative of the other Avanci licensors. And this discussion revolved around the provision of the UK procedural rules, here especially it's rule 19.8 of the civil procedure rules, which allows a so-called representative procedure. What does this mean? It's like, we put it very simple, it is a process which allows third parties to be included in proceedings, especially in the outcome of proceedings, if there is a useful purpose of doing that. So if a decision of the court against a party which is in the proceedings, is participating in the proceedings, if it would make sense to extend, let's say, the effects of this decision to the other parties that are not directly involved in the proceedings, could be involved but are not directly involved in the proceedings. And there are some circumstances where this makes sense. And when these circumstances exist, then what happens is you have this representative procedure, and the judgment that is being delivered by the court, even judgments of a declaratory nature, which were the relevant claims that have been asserted here, then the outcome is binding for the represented parties. And what is also important, it's enforceable against these represented parties, however, only with permission of the court. So here the question was, should this apply in this context where we have only one licensor of the Avanci pool being sued here, but basically you could say that this representative procedure could apply to all other Avanci licensors? Would this change anything in whether the court should deal with the case or not? The court said this procedure, this representative procedure, could have a useful purpose in this case here, because the outcome would be binding for the Avanci licensors as well, if you would go this way. At the end of the day, this would mean that you would have, let's say, a decision, a declaration, which would cover the Avanci pool as a whole, and this would be eventually positive, because you would have a solution which was applicable not only to InterDigital, but broader than that. But again, here, however, the court said that there is a very high risk that these proceedings, if you would go on and do it with InterDigital as a representative of the Avanci licensors, will most likely not be conducted effectively. Again, here, the lack of information, the lack of data was mentioned by the court. And what the court also said here is that even if you would have InterDigital acting as a representative of the Avanci licensors, you cannot assume that the rest of the Avanci licensors will help InterDigital with the trial, provide information, or maybe even join the proceedings, because the court recognized that between the Avanci licensors, there can be conflicts of interests. For example, there can be conflicts of interest between InterDigital and other Avanci licensors. The fact that they have joined all or decided all to join the Avanci pool does not mean that they could not have different interests or conflicting interests. So this, if this was the case, then these proceedings would not be able to proceed in an effective way, because basically participation and information would be missing. Then also very factually, the court thought about what a decision would affect in real life if it was delivered by a UK court in this setting, and had strong doubts whether this decision would be enforceable outside of the UK. And in the specific case, this would be a major issue because in the eyes of the court here, the substantial majority of the Avanci licensors is not UK based. So even if you got a decision and delivered these declarations that Tesla had here requested, at the end of the day, this would be eventually not having any effect because outside of the UK, where most of these Avanci licensors are based, it might not be enforceable at all. Apart from that, there were two other reasons. The court had also some concerns of eventually having an overreach here if you would allow these proceedings to move on in this way, because especially you would create a situation for the non-UK based Avanci licensors, which is rather difficult. So they would have to choose either to basically try to join the proceedings against InterDigital, but this would then mean that they would submit to the UK jurisdiction, although they might not want to. So they would be forced in a way to accept the jurisdiction of the UK courts. And on the other hand, if they would not choose to join the proceedings, then there is a very high risk that they would be inadequately represented in the proceedings by InterDigital. And this would be, again, very dangerous because they would eventually get a decision which is not favorable in proceedings in which they were not adequately represented. So this would basically mean that courts in the UK, if you would allow this representative procedure here, would force the other Avanci licensors to join the UK litigation, and that seemed to be problematic for the court. Then, I'm sorry. Then finally, there was also a very practical consideration of the court here, which saw that it would have been unfair at the end of the day to burden InterDigital with the cost and responsibility of conducting this trial as a representative of 65 plus other patentees. And the main reason why this would be unfair in the eyes of the court was that it seems rather, let's say, not really having a particular reason why InterDigital was involved in these proceedings by Tesla or was sued in these proceedings by Tesla. It seemed to be rather a random choice, and in the eyes of the High Court, Tesla did not deliver particular reasons or good reasons why they have chosen InterDigital to be part of these proceedings as an individual licensor of Avanci, because the court said Tesla, on the one hand, was not approached. Tesla did not approach InterDigital before the launch of the trial. InterDigital, on the other hand, did not threaten to file case against Tesla. So it was rather random why InterDigital ended up being a part of these proceedings, and then giving them all of this burden, cost, and responsibility to lead the trial, basically in the name, or at least for the account of another 65 plus parties that have joined Avanci, would be just too much here and unfair at the end of the day. So this is what the court said about this topic. And since, of course, this first condition was not met either with respect to Avanci nor with respect to InterDigital, the jurisdiction was declined here. Nevertheless, the court made also some final remarks regarding the question of whether England is the appropriate forum, especially what would be the appropriate forum for this claim. To do that, the court tried to identify which is the actual correct characterization of the claims that have been advanced here by Tesla. And given the fact that the patent claims, which refer to UK patents, were relegated by Tesla itself to the second stage of the proceedings, the court saw the focus of this trial, or the core of this trial, in the licensing aspects. So at the end of the day, the claim was characterized as a licensing claim about front terms for a worldwide license of 5G SEPs. And now the question was, for this specific claim, for this licensing claim about a worldwide license, front license for 5G SEPs, is the UK the best forum, or is there an alternative forum? And here, the court basically said that the US courts are an available and appropriate forum, and as we're going to see in a moment, also the best situated forum in this regard. Why? Because the court said they are available and appropriate because they had no doubt that the court in the US, and especially in Delaware, where both InterDigital and Avanci are based, would decide whether the Avanci license is front. So this was one part of the claims that were raised here by Tesla. And then there was some dispute of whether the courts in the US would determine actually which are the rates for the or the terms for the Avanci license. But here the court said, well, if the Delaware court would decide which whether the Avanci license as it is today is front or not, if it would say no, then it is very likely that it would also say what rates are actually front. So that's why the court said Delaware is an alternative forum, so you should have looked at that. And then, having said that you have an alternative forum, so there is another court that is going to do the same job as the English courts would do. The court said that the specific claim has a closer connection with the US rather than the UK. So this should be the choice of for this specific case. Why? Of course, the obvious reason is we said already the main parties are Delaware companies. But apart from that, the court mentioned some other factors. For example, that the majority of the SEPs are US patents, or that in the UK patents, the share of UK patents in the 5G SEPs is very low, only 7%. That's what the court assumed here, that only 7% of the 5G SEPs are UK patents. Apart from that, the Avanci license agreement is administered and regulated in the US. And what is also a factor was the fact that the Avanci master agreement, which is basically the agreement signed by Avanci with its licensors, is under New York law. So all of these elements created a close link of these proceedings and the claims as they have been advanced by Tesla here with the US. So the appropriate forum in this case would have been the US. So this is the decision of the court. At the end of the day, what is the key takeaway is that the court here denied to assume jurisdiction to set the terms of a global front license that should be provided by a pool. And we've seen that the UK courts had not have problems or have assumed jurisdictions in the past to set the terms of licenses for individual portfolios, even global licenses for individual portfolios of individual patent owners. But as far as at least this decision here is concerned, they declined to do that with respect to a pool license agreement. Now, I mentioned at the beginning that there are other jurisdictions that have also looked at that. And here, what I would like particularly to mention for us to keep in mind also as a comparison, there has been a decision from China where a similar question was posed. And there it was the Access Advanced versus TCL case. And there, the Chinese Supreme Court confirmed that Chinese courts would have jurisdiction to set global terms, not only regarding individual portfolios of individual SEP owners. We have seen that already. We had the Nokia Oppo decision some time ago, where the courts did that also for the first time regarding with a global scope. But the Chinese Supreme Court said now that this can be done also with respect to a pool license, a global pool license. And in this case, a license to the Access Advanced pool, which is not wireless standards here, but video coding standards. So maybe here, just for us to keep in mind a difference between these two jurisdictions. So in this, at least in the first instance, in this specific setting here, the High Court of Justice in the UK did not assume jurisdiction to determine what would be the global front terms of a pool license that is offered by Avanci. It seems that the Chinese courts are more open to that, and regarding this Access Advanced TCL case, the Chinese Supreme Court seems to confirm that the jurisdiction of the Chinese court would extend also to setting terms for global licenses for pools, so not only for individual SEP owners. Against this backdrop, it's of course very interesting to see how this further evolves, especially in the UK, whether they will change their mind. But for the time being, this is the status quo regarding this specific question.